Good afternoon. I'm Ken Petroulis. I'll be your host and moderator. I'm a retired trust and estates attorney. For the last 13 years, my wife Dale and I have sponsored the Beverly Hills Bar Foundation Rule of Law Writing Competition, hoping to foster understanding and appreciation of the rule of law. Each year, the foundation solicits nomination of law review articles from law schools. Today's program includes presentations by the winners of this year's competition. Our grand prize winner is Ben Levine, UCLA Law Review, who will discuss his article, Obvious Injustice, hi Ben, regarding qualified immunity as it applies to law enforcement officials and officers. His discussion will be moderated by entertainment law attorney Kenneth D. Freundlich of Freundlich Law. Our next winner is Tia Kerkhof, Southern California Law Review, who will discuss her article, Small Fines and Fees, regarding the use or misuse of minor infractions to generate income by local governments. Her discussion will be moderated by appellate attorney Marc J. Poster of Greines, Martin, Stein Richland LLP. Finally, Sarah Devaney, Pepperdine Law Review, will discuss her article, Justice for All, which explores the use of vacatur laws to expunge the criminal records of victims of human trafficking. I will be the discussion moderator. Although I've retired from my law practice, I still work as a professional fiduciary in trust and estate situations. Each of the winning articles and full biographies of the winners are included in the program materials, which you should have received. Please use the chat box for any questions you may have. At the end of each presentation, time allowing, the moderator will follow up on your questions. Links to the articles and MCLE information will be included in the chat box. And now, Ken Freundlich to introduce our grand prize winner, Ben Levine.
Hi, everybody. Thanks for being here. I'm going to make this really short. Ben is graduated UCLA Law in 2021. Did most of the research for this article the year before and is now clerking up in Sacramento in the Eastern District, the U.S. District Court. Ben's article is incredibly important in terms of things that are going on today. And so I'm going to let Ben give his presentation and hope that we can have some good follow-up from that. Without further ado, here's Benjamin S. Levine.
Sure. Thank you very much, Kenneth. And Kenneth, like was just mentioned, my article talks about qualified immunity, which I'll start off with just a bit of background about that and what it is and what it does. Qualified immunity is an affirmative defense to constitutional claims brought under 42 USC section 1983, which is a statute that allows individual plaintiffs who to allege that they have been victims of constitutional rights violations by state and local officials, including police, prison officials, and other public officials at the state and local level. The statute itself doesn't include any reference to qualified immunity. Qualified immunity was actually created by the Supreme Court in the 1980s. It originally started out as something called good faith immunity, which was subjective and basically asked whether the defendant official, whether it's a prison guard or a police officer or whatever else, had a good faith basis for believing that what they were doing was legal. Over time, though, the doctrine has developed and the Supreme Court has turned it from a subjective analysis to an objective one. And the question has now become whether the unlawfulness of the official conduct, whether or not what the official has done is unconstitutional, would have been apparent to the official at the time in light of existing case law. And since the first decade or so of the 21st century, the court has begun applying this doctrine in Section 1983 cases brought by plaintiffs alleging their civil rights have been violated in more and more strict ways, suggesting that plaintiffs, in order to overcome this affirmative defense, need to be able to identify pretty factually similar precedent from prior to the events at issue that found that that similar conduct violated the same constitutional right. And if they don't, that means that there can be and frequently are situations where a court determines that what the defendant official did was unconstitutional, that the plaintiff did have their civil rights violated, but that they have no recourse because the defendant official is immune. And you hear this qualified immunity can apply really in any case that can be brought under Section 1983, so any kind of constitutional right violation, although it tends to come up mainly in the Fourth Amendment context involving police, in the Eighth Amendment context involving prisons, and sometimes in the First Amendment context too. You see it in public legislative settings where people are kicked out of city hall meetings and things like that, and sometimes in the educational setting, but tends to mostly be in policing and in jails and prisons. So the doctrine as it stands tends to be very strict, as I was just saying, but my research focused on this sort of outlier decision by the Supreme Court that came down in 2002. And that was a case called Hope versus Pelzer. It was an Eighth Amendment case involving a prisoner in an Alabama state prison who was tied to a hitching post out in the sun as punishment for getting into an altercation with a prison guard. And he was left out there for 8 hours with his shirt off, and really just humiliating and painful, getting burned by the sun. And the Supreme Court said, even though there's no case law that's really similar to this, saying that this kind of thing is a constitutional violation, there can be some cases where treatment of a plaintiff by officials, whether they're police or prison officials, can be so obviously unconstitutional that it would have been clear to any reasonable official that what they were doing was unconstitutional, notwithstanding the absence of case law, and that qualified immunity can be overcome that way. And so I thought that was interesting, given the recent trend in the past 20 years or so, notwithstanding that Hope decision, toward requiring factually similar precedent for plaintiffs in order to overcome qualified immunity, because Hope said in some rare cases that precedent really isn't necessary at all. And so I wanted to take a look at the way that courts were applying this, because at the time that I was doing my research, the Supreme Court had never invoked that rule again that said a violation can be so obvious that it overcomes qualified immunity. So, you know, and the effect of this in a lot of circuit courts is that it tends to become the exception and not the rule. And the general rule is really to look for factually similar precedent, especially in the policing context, where the Supreme Court has said that police are called upon to make split-second decisions, and so they're going to need extra specificity in the precedent that you're pointing to in order to know that what they're doing is unconstitutional. It rests, of course, on the assumption that law enforcement officials and prison guards and other public officials are familiar with precedent at a pretty granular level, even though they almost certainly are never reading any kind of case law whatsoever. So I took a look at the way that 4 different circuit courts were treating this issue, specifically the obvious violation exception under Hope versus Pelzer, specifically the 4th, 6th, 8th, and 11th circuits. One of the reasons why I was interested in the 11th circuit was because that was the circuit that the Hope case had come out of. And I found some interesting things. They treat this precedent differently in some notable ways that I argue in my article has an effect on the outcomes in those cases on a macro level, not necessarily on a case-by-case basis, but looking at the overall trends. Overall, the approach that the circuits have taken, I think, was more favorable to plaintiffs, albeit by varying degrees, than the more recent Supreme Court precedent would suggest. And every circuit that I looked at had, in at least one case, found that there was an obvious violation and allowed a plaintiff to overcome qualified immunity that way. But also my research revealed that the different circuits have, in the years since Hope, developed different tests for evaluating when a qualified immunity is satisfied, including with respect to incorporating the obvious violation exception. The Fourth and the Eighth Circuits, for example, do a pretty straightforward inquiry on whether the precedent that the plaintiff has pointed to was factually similar enough to their case to overcome qualified immunity. But others, the Sixth and the 11th Circuits, explicitly in the tests that they have articulated for evaluating qualified immunity, have specifically required the court to consider whether the violation was obvious. And perhaps unsurprisingly, the circuits that are required to consider in evaluating qualified immunity defenses whether the violation was obvious, according to my findings, found obvious violations more frequently. And since I did my research fairly recently, there's been a recent development that I talk about a little bit in the article, but wasn't able to engage with in a ton of depth, just given how new it is. At the end of 2020, the Supreme Court decided another prisoner's rights case coming out of Texas that was called Taylor versus Riojas, and held that really egregious treatment of a prisoner that I won't describe in detail right now, but I do in the article, was obviously unconstitutional, citing Hope versus Pelzer, sort of reviving the rule, because part of the impetus for me doing this research prior to this Taylor versus Riojas decision was the fact that some legal experts and scholars were sort of assuming that Hope and the obvious violation exception was kind of a dead letter because it was from 2002, and in the 18 some odd years since then, the Supreme Court had been pretty substantially walking away from that. So that's really the upshot of my research.
I'd like to engage with you a little bit on this, but first
Sure.
I want to just remind everybody in attendance that we're encouraging questions in the chat or in the question, and we'll try and get those in. I've read your article a couple of times now, and I find it incredibly engaging. And the thing about it that really jumped out in my mind was the old adage from, I think it was the George Carlin case, you know, that obscenity is something I know it when I see it. And it seems to me that like everything else in this crazy time we're living in, depending upon the political proclivities of the circuit, certainly in police brutality cases, that any decision can be made that they want to make, essentially. That it's like the end gets, they said, okay, this is no good, and then they figure out how to do that. Could you just sort of comment on your thoughts about that? Because to me, if you're going to only talk about factual similarity, that just seems incredibly narrow, right? Because there's no limit to the amount of things. I mean, we see a knee on George Floyd's neck. There may not have been a time when a knee was on someone's neck, right? But we all, I think most right-minded people know, having seen that's obviously, should not give anybody any immunity. Let's put it that way.
Right. Yeah, I agree. I think just generally, I think it's worth noting that the entire defense and doctrine of qualified immunity is really sort of taking back authority for the courts to immunize public officials where Congress did not intend them to be immunized. Like I mentioned at the top, qualified immunity does not appear anywhere in any federal statute, including Section 1983, which is what it's a defense to. So requiring factually similar precedent, I think, gives courts really a lot of license to go either way, to say, really any case can be distinguished on some facts. Whether those distinctions should be important or matter is really sort of a question that's up for debate. And so, I think the basic requirement really gives courts a lot of leeway to say, even in these circumstances where there has been a constitutional violation that Congress has said should be remediable through the courts through these Section 1983 actions, that we're nonetheless going to immunize defendant officials. So, and I think that the obvious violation exception really, in some ways, you could look at it as giving courts another layer of discretion but in that case, the discretion is more oriented toward breaking out of the requirement to, in certain cases, give defendants qualified immunity protection and say, this is so bad that even though there's no factually similar precedent, we're going to allow this individual to be held liable.
Did you find in your research that there were when the court used the factually similar analysis, they were sort of leaning towards finding qualified immunity versus when a court engaged with the obvious injustice rubric, where it seems like by going there, maybe the court is going to find, more often than not, going to find that it was an obvious injustice. Sort of like what happened in Hope. I mean, you tied to a hitching post and let out in the sun for 8 hours because you had an altercation with a prison guard. Seems pretty obvious to me, at least.
Yeah, I mean, I think, generally circuit courts that have denied qualified immunity to public officials have gotten reversed a lot by the Supreme Court and have been admonished in those reversals for not scrutinizing the precedent closely enough. And the court in those reversals found there are these distinctions between the precedent that the circuit court said was similar and the instant case, and granted qualified immunity on that basis.
Have we found those Supreme Court cases to be divided, as so many decisions are these days, on political grounds? Are there dissents in a lot of them?
There are dissents, but interestingly enough, a lot of these Supreme Court cases have been per curiam, which is to say nobody is putting their names on these cases. So you might question why that is. And there also there have been some dissents, but not as many as maybe you might expect. But sort of just to your question a moment ago, I think that when circuit courts are engaging in this sort of more fact-intensive analysis, they're doing that because they think that they're obligated to because of what the Supreme Court has done. But then within that, they really can and have gone either way in terms of the outcome. And so, you might say that in some cases it's performative. They have to go through these motions, but then they're either going to distinguish the case or not distinguish the case, depending on which way they feel it should go and which way they think that the precedent leans in terms of supporting qualified immunity.
Okay, so another thing that kind of stuck out at me, and I wondered if you had any thoughts about, is the role or the lack of a role of a jury in any of this decision making. It seems like, from what I could tell, these immunity decisions are being made by judges based on facts that the judges are finding, and it just something seems a little off on that. Because if you were in a typical situation where you're talking about a defense, then you normally put that on in front of a jury, and there were findings of fact and stuff. But this immunity thing seems to cut out the role of a jury, which, when you're dealing with something, a concept of obviousness, seems really unfair. Did that cross your mind, or did that come up in any cases?
Yeah, I mean, I don't know that it was addressed in that respect in the cases itself, but yeah, qualified immunity is a question of law, so it's always being made by the court. If it's subject to whatever the applicable standard is for considering the facts and whether they're true or not, such as on a motion to dismiss, or drawing inferences in the plaintiff's favor on a motion for summary judgment. But yeah, I mean, and the inferences that are drawn from the facts as alleged in the complaint or as presented in the evidence in the case of summary judgment motion, are really for the judge to make, and so that really, I think, showcases how much discretion judges have in making these qualified immunity determinations. Qualified immunity is sometimes decided at trial. So if a court says there are too many factual disputes that really go to the heart of the issue of whether this case is similar to X case that was decided 5 years ago, then those facts can get hashed out at trial, and the finder of fact, whether it's a bench trial or a jury trial, will make those determinations. But then qualified immunity can be raised at that point, and then it's for the judge to say, well, these facts are or aren't similar enough.
Okay, we got time. I think I have time for one more quick one. I think we, by the way, had two questions that were both related to my jury question. I think we disposed of those pretty well, and I thank you for that. Do you know of any cases that are either potentially winding their way up to the Supreme Court or may get to the Supreme Court? I mean, I think with all this police brutality, the focus we've had, I mean, it started off as a prisoners' rights thing, but in terms of the police brutality cases, do you think that there is any cases that are going to make their way up there? I mean, I hate to think of what the results might be, but I just wonder if we're not going to get something up there.
There have been tons of cases that have been petitioned for cert to the Supreme Court, coming out of all kinds of circuits, and I talk about this in the article a bit, but the Supreme Court has really shown very little appetite for substantively addressing any of this. They sometimes reverse denials of qualified immunity, saying the circuit courts need to do more. On very rare occasions, they do the opposite, like in this Taylor versus Riojas case, but even then that was a memorandum disposition. And in 2020, there was a big group of consolidated cases, policing cases, prison cases, that there were really accomplished advocates who had tried to get Supreme Court review on them to try to address what really are the boundaries of qualified immunity, and how should it really be operating, at least get more guidance to lower courts, and cert was denied on all of those. So
okay, we hit our 12:52
Yeah.
mark. I just want to say for the record here that I was blown away. I thought your paper was just excellent in its presentation and its thoroughness.
thank you.
And I think you have a really great future, and hopefully you'll stay connected to this bar association wherever you may go, and always be pushing for the rule of law, whatever it is you do.
Thank you very much, and very grateful for the award. I appreciate it.
Well, we're grateful to you, Ben. That was a wonderful paper. As judges, we all enjoyed looking at it. And thank you to Ken for doing a great job of discussing your article with you. And now it's time for Mark Poster and Tia Kerkhof. Mark, take it away. You're muted, Mark. So is Tia.
Thank you, Ken. And thank you for being the driving force behind this whole rule of law program. And I concur with Ken Freundlich that all the articles we received this year were excellent, and it was a tough choice as to which got the prizes. And okay, so I'm moderating Tia Kerkhof's presentation of her Southern California Law Review article, Small Fines and Fees, Large Impacts, Ability to Pay Hearings. Tia graduated from California Lutheran University and recently graduated from the University of Southern California Gould School of Law. After taking the bar exam in July, she will be a judicial clerk for the U.S. Court of Appeals for the Ninth Circuit. And just some background on this, even where the laws are properly adopted and scrupulously enforced, it doesn't always mean justice has been satisfied. As Tia argues, the law sometimes must be changed. And I have to give full disclosure here, the very issue that Tia discusses is before the California Supreme Court in a criminal case awaiting oral argument. And the Beverly Hills Bar Association has filed an amicus brief in that case. So Tia, tell us about your article.
Thank you for the introduction, Mark. So I started sharing my screen. So as Mark mentioned, my presentation today is titled Small Fines and Fees, Large Impacts, and I basically argue that ability to pay hearings are a remedy. So many jurisdictions across the country use fines and fees to help finance elements of their criminal justice systems. These fines and fees are referred to as legal financial obligations. In short, they're called LFOs, and they impose major burdens on low-income individuals, creating a poverty penalty because they're imposed regardless of one's income. So in 2015, the Federal Reserve System found that 46% of adults could not cover an emergency expense costing $400 upfront. And so a lot of the legal financial obligations appear very small, but they actually have a very large burden for many Americans. So I basically argue that ability to pay hearings, ATP hearings, are constitutionally required before imposing fines and fees and ATP determinations can remedy all the issues with LFOs, or not all the issues, many issues. And I'm going to do this first today by discussing some background. So I'm going to distinguish the various financial obligations, and then I'm going to discuss the burdens that LFOs impose on society when they're imposed without ability to pay hearings. Second, I'm going to analyze 14th Amendment violations when LFOs are imposed without ATP hearings. I also discuss 8th Amendment violations in my article if you're interested in that argument. And third, I'm going to address a lot of concerns surrounding ATP hearings, and these mainly have to do with administrability, revenue downturn, and racial justice issues. And lastly, I conclude with the designing of these ATP determinations. So while all LFOs can have similar harmful impacts, their original goals are distinct. Fines are typically imposed once someone is convicted and are designed to deter and punish illegal behavior such as traffic violations, misdemeanors, and felony offenses. Fees, on the other hand, are intended to raise revenue and to recoup operating costs of the justice system, and they often bear no relation to the offense committed. So these can include court-appointed attorney's fees, court clerk fees, DNA database fees, jury fees, room and board for jail stays, and so on. And then restitution is typically a court-imposed fee to compensate victims for emotional and psychological losses. And it also bears mentioning that cash bail contributes to criminal justice debt, but is out of the scope of my article in this presentation just because it comes with a whole host of other issues. So LFOs can quickly accumulate and amount to insurmountable debt, which causes numerous negative impacts. This includes an endless cycle of debt because interest rates can be very high. It also leads to debtors' prisons, which the Supreme Court, as we know, has technically held that they're illegal, but there's a new form of debtors' prisons where states are allowing willful incarceration for willfully missed payments of LFOs. They allow for arrest for failure to pay or appear at debt-related hearings, and the choice to spend time in jail to pay down court-imposed debt. Non-payment of LFOs can also lead to driver's license suspension, even when underlying offenses do not involve vehicles. And lastly, LFOs impact voting rights, with 17 states making payment of criminal justice debt a precondition to restoring voting rights after conviction. So numerous studies have established that LFOs imposed on indigent defendants are counterproductive because collection costs offset amounts collected, and because criminal justice debt increases future costs because individuals struggle to support themselves. So for example, in Minnesota, a 4-month program collected a little over $7,000, but it cost $13,000. In 2009, in Chippewa County, a little over $44,000 was billed, and less than half of that, just a little over $20,000, was ever paid. And then in New Orleans in 2015, the cost of jailing people in the city who could not pay fines, fees, or bail amounted to $6.4 million. Comparing this with the $4.5 million in revenue obtained from the LFOs shows that imposing LFOs rarely justifies the cost of the collection efforts. Furthermore, collection processes are expensive as well, especially against individuals for smaller sums of money, because there's staff time for court costs, prosecution costs, and costs of extending probation for non-payment to pursue the LFOs. Ultimately, this offsets the revenue secured. And then lastly, this can result in a cycle of poverty for indigent defendants, which can have long-term effects on the criminal justice system, such as increased probability of recidivism, increased homelessness rates due to hurdles to find housing and to poor credit scores, increased unemployment, barriers to paying child support, and loss of public benefits due to ineligibility for programs like TAMF and SSI. Many LFOs directly fund criminal justice systems, creating conflicts of interest. In many states, there's no limit on the amount of revenue that can be collected, or the amount of revenue that the courts can raise. And there's also no limits or guidance on where the money can be spent. So this leads to judicial policymakers and judges using the courts as money-making institutions. And lastly, LFOs contribute to racial disparities, with charges falling disproportionately on Black and Latinx communities because of over-policing of people of color and because of the excess imposition of violations for minor nonviolent offenses, such as traffic infractions. On a national level, 12% of Black families reported unpaid legal expenses, fines, or court costs, and that's compared to just 5% for white families and 9% for Hispanic families. So the 14th Amendment Due Process Clause bars courts from imposing unpayable fines and fees on indigent defendants. In Bearden v. Georgia, the court created a test for the constitutionality of court processes that threaten to disadvantage criminal defendants because of their indigence and created a prohibition on punishing a person for their poverty. So the test is on the slide with 4 requirements, and lower courts have applied this to requiring ability to pay determinations before LFOs are imposed, and they vary in their holdings. Basically, the first 2 Bearden factors weigh heavily in favor of finding due process violations when courts impose any legal financial obligation without inquiring into a defendant's ability to pay, because unpayable LFOs implicate both economic and liberty interests. This results in cascading consequences from the loss of driver's license, voting rights, housing, and public benefits, to name a few consequences. One court discussed these collateral consequences and noted that indigent offenders owe higher LFO sums than their wealthier counterparts because they cannot afford to pay, which allows interest to accumulate and to increase the total amount they owe. That LFOs increase the chances of recidivism because they inhibit reentry with legal or background checks showing active records that can have serious negative consequences on employment, on housing, on finances, and on credit ratings, making it more difficult to find secure housing. And that significant disparities exist in the administration of LFOs with drug-related offenses resulting in trial, Latinx defendants, and male defenders all receiving disproportionately high LFO penalties. So these consequences are weighed against the legislative purpose and existence of alternative means, which are the last 2 factors. And the purpose is typically to either fund court operations or punish defendants. But as I mentioned, most unpaid LFOs are uncollectible, and so the system isn't fiscally sound. So an expenditure study in New Orleans, Louisiana, showed that its use of incarceration to address the inability to pay bail, fines, and fees created a 1.9 million annual deficit. So there's really no justification in that it's funding court operations. And then in terms of punishing defendants, indigent defendants don't come to the decision not to pay. They don't pay because they cannot pay. And so it's really not a true decision. And so there's no bearing on responsiveness to punishment or deterrence. And in terms of alternatives, courts can get funding from LFOs imposed on those who can afford them, having indigent defendants pay an amount that they can actually afford. So in terms of punishment, ATP hearings would still require an amount commensurate to a defendant's ability to pay. And if they really truly cannot pay, then they can have other things such as services or community service, which can be imposed. So thus, under due process analysis, I argue that courts are constitutionally required to examine a criminal defendant's ability to pay any type of LFO before imposing it. So now I'm going to address major concerns surrounding ability to pay hearings. So a lot of ability to pay opponents are concerned that obtaining financial information may be too difficult, that defendants will inaccurately self-report financial data, or performing ability to pay calculations will overburden courts. So courts already use financial data self-reporting to assess whether a defendant qualifies for indigent defense, representation in pre-sentence investigations, and to set bail. So these courts can use the exact same information, and this would not require more intrusiveness into a defendant's life. While there may be some degrees of inaccuracy in self-reporting, some research has shown that people who are surveyed regarding their income typically provide consistent, although not necessarily perfect, estimates of their legal income. And courts could also use spot checking verification. And lastly, pilot projects have shown that calculations can be efficiently completed with simple forms and tables that compute adjusted daily income. And so courts really wouldn't be overburdened by this process. So the second concern is that the fiscal effects of ability to pay determinations and revenue generation. So in some jurisdictions, LFOs are a source of revenue generation, and so they're kind of viewed as a necessity. And however, there's a strong indication that jurisdictions are losing revenue from the expenditures necessary to collect LFOs from individuals, as I already mentioned. Comparative costs and expenditures to enforce LFOs could be significantly offset by other savings, such as a decreased need for oversight, declines in costly punitive measures for failures to pay, and potential reduction in costs as a result of reduced recidivism rates. And lastly, pilot projects show that a person's belief that they can pay an LFO leads to greater efforts to complete payments. And so these pilot projects suggest that ability to pay hearings can actually improve revenue generation because the amount that a certain defendant has to pay would be surmountable. And the last major concern is that some scholars argue that ATP determinations don't lessen existing racial injustice and that they happen behind closed doors where there's no oversight or regulation. And so although ATP determinations in hearings wouldn't fix all racial disparities within the criminal justice system, like over-policing of minority communities and pretextual stops. They do lessen the wealth extraction from Black and Latinx communities and halt disenfranchisement based on the inability to pay criminal justice debt. And in terms of lack of oversight, I argue that ATP determinations should require notice from the judge, or defense counsel should be required to ask for a hearing, and that counsel should be present at these hearings. So in terms of designing ability to pay hearings, when a defendant has a source of income like employment, public benefits, business income, and so forth, there's really no need to speculate as to their future income, which makes the base income determination pretty straightforward. To address situations in which a defendant is unemployed at the time of sentencing, but may be employed in the future, jurisdictions could establish systems that assess the likelihood of future employment. So for example, some courts in Oregon examine whether a defendant has substantial prior work history and specific employment prospects in the future. And after establishing base income, ATP hearings should account for defendants' ability to meet basic necessities, such as housing, food, medical care, and so forth. And a model with flat deductions dependent upon whether a defendant fell above or below the poverty line would account for people at the low income levels being hit the hardest by LFOs. This is also consistent with how the government establishes federal financial aid. So the hearing could take into account other financial obligations such as child support payments or student loans. And since most defendants are unaware that they have to request the ability to pay determination in jurisdictions that allow for them, requiring a judge to hold an ability to pay hearing when a defendant is unrepresented or having appointed public defender represent the defendant's interests will protect the defendant, legitimize the proceedings, and allow for effective determinations. So even those without income will still pay through non-incarceration alternatives, such as community services or supportive services involving training or treatment. So in conclusion, ability to pay determinations could lessen the poverty penalty, relieve racial disparities, restrict debtors' prisons, alleviate conflicts of interest, lessen recidivism rates, increase revenue for many jurisdictions, benefit families with criminal justice involved individuals, and improve the cycle of poverty for indigent people. And that's the end of my presentation. Oh, Mark, I think you're muted.
Yeah, thank you, Tia. That really thorough. We just have a couple of minutes. I just wanted to ask you, so the Bearden versus Georgia case from the Supreme Court that set out all these due process considerations, but has the Supreme Court in any way followed up on those as to what exactly, how to carry out to ensure that those considerations are guaranteed?
Yeah, so the Supreme Court hasn't directly addressed this issue. As you mentioned, the California Supreme Court is currently looking at it, but I believe they're only looking at two major issues, and that's whether the state has to prove ability to pay or the defendant must prove inability to pay. And then the second major issue is whether the defendant has to affirmatively raise an ATP hearing or whether the court has to consider in all cases. And so the Supreme Court hasn't really followed through on the Bearden analysis. And even within lower courts, a lot of them don't apply the straightforward 4 factors. Some of them just kind of dismiss it initially, or they'll look at specific things such as driver's licenses being revoked, even when underlying offenses have nothing to do with vehicles. And even then they'll just dismiss it and they won't apply the 4 factors. And so I think if courts followed through with the Bearden analysis, they would find that these hearings are constitutionally required.
And if you know, in the case pending in the California Supreme Court, is that going to be based on the California Constitution or the federal Constitution, or both?
I think the lower court looked at both, but I'm not sure exactly what the state Supreme Court is going to look at.
And finally, if I could, for 30 seconds, can you tell us what got you interested in this particular issue?
Yeah, so my dad's side of his family is all former law enforcement or current law enforcement. And then in undergrad, I interned at the U.S. Attorney's Office in Washington, D.C. at the state level. And I saw a lot of injustice. And so I've always been interested in criminal justice reform in general. And I think currently, right now, the movement is sort of focused on over-policing, racial bias, pretextual stops, and sort of the policing aspects. But I think people need to focus also on the prosecution and what's occurring in courts and the cascading effects there. And so because of that and the current Supreme Court, California Supreme Court looking at the issue, I kind of grew more interested with this.
Well, thank you, Tia, and best of luck.
Thank you.
And thank you, Mark and Tia, for that great presentation. I have the pleasure of introducing Sarah Devaney, a 2022 graduate from Pepperdine Caruso School of Law. Sarah, a Chicago, Illinois native, graduated magna cum laude from the University of Arizona in 2017, majoring in English with a minor in business administration. At Pepperdine Law, Sarah served as a literary citation editor. A passionate human rights advocate, Sarah spent her 2L summer working at Pepperdine's Restoration and Justice Clinic, representing victims of human trafficking. Sarah plans to remain in LA and work as a transactional attorney in the entertainment industry. And Ken, did you hear that? You have a potential associate here. Her article, Justice for All, explores the use of vacatur
Got it.
laws.
Thanks.
You're welcome. To expunge the criminal records of victims of human trafficking. She urges reforms to vacatur laws to help trafficked persons seeking to reclaim their lives, but who are haunted by crimes they were forced to commit. In particular, I was struck by one quote from her article, which I think will serve as a good introduction. While expungement clears a survivor's record by rendering the record unavailable, vacatur reverses the conviction and validates the survivor's role as a victim rather than a criminal. And Sarah, with that, take it away.
Perfect. Thank you so much for that introduction. I'm going to share my screen. Let's see. All right, perfect. So as Ken mentioned, my article explores the treatment of human trafficking survivors by the criminal justice system and how their records can be vacated via an expanded and comprehensive implementation of a federal vacatur law. So just really quick before I start, a vacatur law is just what I mentioned, that quote, it goes beyond sealment and expungement, and it actually vacates the conviction and essentially recognizes that the person should not have been convicted in the first place, rather than just, not being able to see the conviction. It says that this was a mistaken conviction. So it really does validate the person that was convicted's role as someone who was innocent and who was misjudged by the criminal justice system. So it's common for human trafficking victims to acquire a criminal record as a result of the activities that they're forced to engage in while being trafficked. And then once these victims become survivors, their criminal record hinders them from wholly reacclimating to society. The current state of human trafficking laws provide little to no relief for human trafficking survivors when it comes to alleviating their criminal records. And then accordingly, the human trafficking survivors are perpetually victimized by the United States criminal justice system. So my article, Justice for All, explains the epidemic that is human trafficking and explores the vacatur law that is currently in place in California, which I use as a model for arguing for a federal implementation of a vacatur law, because California does have one of the most expansive vacatur laws. They're graded on a 3-level system, and some states have no vacatur laws, and California has one of the most comprehensive. So I use that as a model, arguing for why it should be changed and then implemented federally. And then I also detail the federal and state laws surrounding human trafficking, the scope of the issue, the tactics that are involved in broadening that scope, and the way victims of commercial trafficking have been treated as defendants by the system. I also discuss and evaluate the importance of vacatur laws, analyze the effectiveness of California's, and then explain that the impact of this expansion would essentially better the juvenile justice system. I conclude by arguing that the expansion of the vacatur laws and the implementation of the expanded version is necessary to facilitate a system that provides survivors with the protection and the fresh start they deserve. So when I refer to human trafficking, I am specifically referring to sex trafficking, and sex trafficking is defined as the recruiting, harboring, transporting, providing, obtaining, patronizing, or soliciting of an individual for the purpose of commercial sex acts. So as of 2016, a study that was conducted by the International Labor Organization approximated that 40.3 million people are victims of human trafficking. And most people believe that human trafficking victims are picked up off the street or in a dark alley. And a lot of times, these victims are being trafficked by their parents, their boyfriend, someone that's close to them. So they don't even exactly realize that they are being trafficked because it's a situation that is so just commonplace to them. So you're probably wondering why the implementation of these vacatur statutes would help to avoid injustice. So before attempting to understand that, I'm going to explain why it's necessary to understand how the survivors become victims, and then how they accumulate a criminal record, and then the impact that record has on the rest of their lives. So the manipulative tactics that comprise the human trafficking process play an immense role in the psychological complications survivors face. And the combination of the residual psychological issues and extortion by their traffickers commonly results in the victims having to commit crimes in order to survive. So they're charged with these crimes and are left with criminal records, which creates the need for the vacatur laws. So traffickers recruit victims by various methods, and then they use manipulative tactics to emulate trauma bonding in order to coerce the victims into forced sexual exploitation. So traffickers typically target young women in dysfunctional homes or abusive situations, hoping that the recruitment process will be less difficult. They use violence, manipulation, false promises of well-paying jobs or romantic relationships to lure victims into trafficking situations. And then in the age of social media, traffickers essentially have a menu of victims to choose from. So the tactics invent and perpetrate the circumstances that lead victims to committing crimes. So a lot of times the victims are charged with prostitution as they're picked up on the street, but obviously they're not engaging in prostitution, they're victims of sex trafficking. And then they also have to commit crimes like theft, false identification, using false identification, because they're stealing things like toothpaste or hairbrush, things that they need to live. And then their traffickers force them to use false identification so that they can't be found. So the crimes that they're committing during their trafficking are not crimes that they're choosing to commit. Which another thing that complicates matters is a lot of these laws are on a state level, which doesn't necessarily help because traffickers commonly cross over state lines and bring their victims into other states, which means that if they have like an arrest warrant in Florida and then one in California, it's really hard to wholly get rid of their record because of the conflicting state laws. So currently there's no federal version of relief for human trafficking victims. However, 44 states have enacted a criminal record relief statutes for victims, and the survivors protected by the individual relief statutes vary depending on the specifications and interests of each state. So for example, 4 of the 44 states provide survivors with criminal record relief only for victims under the age of 18. And then some provide them relief depending on what they are charged with. So again, expungement removes the conviction from a person's criminal record, but a vacatur would completely clear the conviction from the victim's record, acknowledging their status as a survivor rather than a perpetrator of a crime. So California's 2017 vacatur law is one of the most expansive, and it allows not only for the vacatur of prostitution charges and convictions, but offenses related to prostitution charges and convictions, and also the vacatur of other nonviolent crimes that are directly related to the survivor being trafficked. So those typically include drug possession, theft, truancy, but they need to be directly related to their having been trafficked, which is sometimes hard for the victims to prove. So I go on to argue, I discuss the pros and cons of California's law, and I argue that they should get rid of the phrase directly related to. It's really hard for a survivor to prove that something was directly related to their being trafficked. Like stealing toothpaste, for example, was necessary because they have to prove that during that period they were actively being trafficked. So I argue for just replacing that with related to, so that there's a lower burden of proof when trying to get those truancy crimes or drug possession or theft or use of a false identity crimes vacated. And then I also argue that they should go beyond crimes of just prostitution, which California does, but other states don't. So when adopting it federally, it needs to go beyond just prostitution. And then I also argue that it should be expanded beyond nonviolent. So at the beginning of my article, I discussed one specific survivor who has been working for a long time to try to get her crimes vacated. And she, as many survivors do, in self-defense, killed her trafficker. And that is never allowed under any of these laws. And I argued for, taking away the word nonviolent, and in cases of self-defense that these survivors can protect themselves, that those should be considered when attempting to vacate a criminal conviction. So, and then I discussed the roadblocks to implementation. So there's a lot of roadblocks to implementing this sort of federal law. And one of the biggest ones I found to be in my research was policymakers and decision makers and law enforcement and people who would help in enacting these laws just don't really understand that these people are not willingly engaging in these acts. So education is the primary way to start to implement laws like this. So I suggest that different sorts of educational programs be implemented in order to educate judges and lawmakers who can understand the intricacies of what happens when someone is trafficked, so that we can attempt to wholly alleviate them from their criminal record. And then I discussed how exhaustive relief would come from implementing this. And then so I discussed the psychological impacts that being trafficked has, and how implementation of this expansive federal law could help survivors acclimate to society, because it would make them easier to acquire things like employment, housing, and education. Because even if they're extricated from their trafficking situation, because they have this criminal record, they can't, get a house, they can't become a teacher, they can't, adopt children, things like that. So it would change the narrative and adopt victim-centric relief rather than making survivors feel like they're criminals. And then survivors are more willingly to become advocates, which then helps other survivors. I also talk about COVID-19, which you would think it might have stopped human trafficking a little bit, actually made it worse, because it made people more accessible online. And traffickers can kind of, hide themselves and get people online. And also people who are in the same house as their abusers are stuck in the same house with their abusers. So the abuse is just perpetuated further. So I say that these laws could help during a time of COVID-19 when the trafficking is just getting worse. So ultimately, I argue that the most effective way to combat human trafficking is by decriminalizing survivors, and that there needs to be expansive alterations to California's current law in order to implement a federal uniform vacatur law so that all survivors can acquire this kind of relief. And that's it. Ken, I think you're muted. Wait, Ken, I think you're muted. Sorry.
Well, there you go.
Yeah.
I talked about everyone else. So it sounds like we have a lot of work to do in terms of vacatur laws. Are there any groups out there actively trying to educate legislators or law enforcement groups?
Yeah, there are. So there's a human trafficking initiative group, and I discuss it in my article how their kind of programs can be implemented to address these kind of things. There's a lot of advocates that kind of advocate and educate survivors, but not too many that do it on the other end where the actual policymaking would happen. So there's lobbyists and things like that. But I think there's a need for a more structured way of informing decision makers.
And it seems also that there are a lot of steps in the process here where there could be attempts to help the victims, including prosecutors or defense attorneys, for example. What are the barriers that defense attorneys have to raising defense of coercion?
Yeah, so it's also education, and then it's also just the laws. A lot of times the clients, and it's also the clients, a lot of times they don't want to go into court. They're scared. I worked with trafficking clients over the summer, and they have to use, fake names, because a lot of them also have children that are from their traffickers. So they're worried about their children. So they don't want to take these cases too far. That's another barrier. And it's honestly, the process is just so slow. Everything takes time, and the burdens of proof are just like a barrier at every single step. So education, people don't want to fight these cases out of fear. And it's just the current state of the laws. It just kind of seems like a losing battle.
One of the things you mentioned was instead of characterizing the conduct as prostitution, characterizing it as sex trafficking or having been trafficked. Is this ever a viable defense? And if not, why?
So it is in states that allow for the vacation of prostitution. I've never seen it stated as, sex trafficking. It's a viable defense, essentially, if you can prove that it wasn't prostitution and you were being sex trafficked. So again, you don't have paperwork signed by your trafficker stating I was being trafficked. So that's another problem, I think, trying to change the language, because the argument against that, which I discussed in my paper, is that there are people willingly engaging in prostitution. And I don't think that that's going to really be relevant when you're trying to argue that you're being sex trafficked. So that's another area where the law could be changed to, instead of calling it prostitution, to call it being sex trafficked.
So one of the things that you had mentioned, and I saw in an article yesterday in the LA Times, was the discussion of this woman who had been convicted of murder many years ago for what today might be considered self-defense against an abuser. Do you see the law evolving in a direction to help victims of violence?
Yes, I do. So actually, that article is about the woman that I use as my example throughout my paper. And I do see the laws changing. It's happening slowly, but it is happening. And I think that's the biggest step. So here in California, she's here in California and she's in discussion. Arnold Schwarzenegger actually was the one that kind of pardoned her, and she's still fighting with Newsom. So it just depends on the laws changing here, but I do see a positive trend in them changing.
And hope beyond hope, you mentioned the possibility of federal legislation. Is there any potential sponsor or pending legislation now?
Yeah, so I didn't see a lot about that. That was more me being idealistic, because right now to get pardoned, the president has to grant you clemency. So I made a constitutional argument as why the federal law should be adopted. But I don't see a lot of movement on that front just because the deference of power to the states.
Yeah, well, it's a very difficult situation and an example of where law enforcement has a tendency to go after the victims because they're easier to prosecute. So thank you very much for your presentation, and we can only hope that some of your suggestions are adopted. And so I think that's about it for our program today. I don't see any questions. Oh, there was a question about a coercion defense. Should the court consider, or is the court able to consider coercion defense in these trafficking cases?
Yeah, so that just goes into what statute they have and how viable that is. That's not that I've seen an explicit defense to anything. It might be like a mitigating thing, but mostly it wouldn't be in like cases of theft or things like that. That might go towards if there was like a self-defense issue.
All right, and also there's a mention of a UN anti-trafficking group involving Julia Ormond. Have you ever heard of them, or are you aware of their work?
Yes, I have. There's a lot of really, really great human trafficking organizations that are doing great work. So yes, that's good.
Okay. Well, thank you for your fine paper, and thank you to all of the presenters and moderators today. And that's it. Check your email for your MCLE certificate, and thank you all for joining us.